The final argument set for today is Micah Lee versus Angie Lee. It is case number 17CA011235. Angie Lee did not file a brief and is not present for arguments here today. Attorney Weitzel is present on behalf of Micah Lee.
That is correct.
Now, you will have 15 minutes to argue. If,
This may end much quicker than you
since there is nobody on the other side for this, of course, there's no rebuttal, so we'll give you the 15 minutes. Parties, the court has read the briefs, so it is, looks like it's noon now, so we can proceed if you're ready to proceed.
My name is Attorney Holly Weitzel, and I do represent Micah Lee with regards to the appeal of this case. This is a contested divorce case. Parties were married on March 15th, 1991. 2 children were born as issue of the marriage, one Malachi, who was an adult at the time of the divorce, and one minor daughter who was born in 2002, on February 2nd, 2002.
I'm going to interrupt you and just remind you of our rule that please
No
don't
names
use the
of the
names,
child.
just the initials.
You got it.
Thank you.
Not even those. The divorce was filed on 7/11/2011. There was a 7-day trial that commenced on 3/6/2014 and terminated on 5/15/2014. 2 years after the case was finally heard by the trial court, the court issued a judgment. That judgment was issued on 3/18/2016. That judgment was appealed, but it was not a final appealable order. The basis of the finding that it was not a final appealable order is that the court had not addressed certain issues, certain complaints that had been raised in the case, third-party complaints, including civil conspiracy, racketeering, I believe is one of the complaints, accountings against third-party defendants, civil claims against third-party defendants. Not a motion to join an additional party and suggesting that there were assets being held by that third party. These were third-party civil complaints that the court allowed to go forward in its court, in its domestic relations court. On 8/19/2016, the trial court again issued what it considered to be an amended judgment, amended final judgment, based on the motion of, the appeal was filed in that case, and because it did not appear that it was a final appealable order, and for fear that the court would go forward and do other things with that order, that case was also appealed. This court did send that case back down on the grounds that it was also not a final appealable order because the issues with civil complaints had not been addressed. Finally, 6 years after the filing, on November 2nd, 2017, the court filed the judgment upon which we are here today. The appeal consisted of 7 assignments of error. Those assignments of error are set forth in the brief of appellant. I believe that those issues have been set forth fully, and if this court has any questions with regards to those issues that I've set forth in the brief, I'm here today to answer any of those questions. However, more importantly, I think that this court has the right, the duty, and the authority to act on its own with regards to issues that might appear. In other words, they have the right to make a decision on this case based on their observations, that this court can say that we can reverse on other grounds. And I'm here today to suggest to you that perhaps for the first time in my career, that is something I am asking this court to do. And the basis of that is the repeated violations of due process. I only represent Micah Lee. I believe that I have fully and sufficiently set forth those arguments. However, this trial can only lead to one conclusion, and that is this is outrageous. It is outrageous. First, it's outrageous to allow someone to amend a complaint and then to begin the case without those parties being there. Then it's outrageous to say that, okay, we're going to allow you to get an attorney. I can see you don't understand what's going on, so I'm going to allow you to get an attorney. I'm going to sever these claims, and I'm going to give you notice of your further hearing, and then to issue a default judgment against those defendants. and then without notice. No notice based on an oral motion. It's furthermore, and you can only get this by reading the transcript, which is thousands, several thousand, a couple thousand pages long. But more importantly, there were allegations without any evidence at all when there was cross-examination. Cross-examination of Brian Perry, I believe it was. And I have the accusations of him using ecstasy. No, I don't use that. What are him using Molly's? What's Molly's? Ecstasy. I don't know what that is. Okay, this is based on, this is the wife. Okay, we're going to take you in. How about if we give you a blood test right now? Okay, fine. I got $29 in my pocket. You take it and get a blood test. Objection, Your Honor. Objection. I'm going to hold that drug test thing in abeyance. It is an outrage. An outrage. I've never seen anything like this, ever. That was at page 354 of the transcript. Shane Edwards, who was one of the witnesses, was before the court, and they asked if he had a felony. The answer was yes, he had felony non-support. For an additional 15 pages, from 276 of the transcript to 282 of the transcript, he is repeatedly questioned about his problems. You would have thought that he was the party that the trial was regards to him and his obligations, outside evidence. Brian Perry, they had repeatedly questioned him about an OVI, even over objection. There were questions about, I'm sorry, let me calm down. There were attacks on a man's religion because he was a Jehovah's Witness, because the defendant or the plaintiff was a Jehovah's Witness. At page 103, one of the witnesses, Collier, it was suggested that because they were brothers, that he would lie for the plaintiff because he was a Jehovah's Witness. That went through. There were repeated allegations that Laura Douglas, one of the third-party defendants, who was also the girlfriend by this time of Micah Lee, had somehow had something to do with the fire of 2003. No proof, no evidence. The mere fact that she drove by, saw the fire, and stopped to help. We're going to suggest that you may be starting the fire. Outrageous. Outrageous. Not only that, but suggestions that people are drug addicts, that they were in the hospital because they were taking drugs, that you started this fire. These allegations, in the absence of the absolute judicial immunity, these suggestions, these innuendos, and these allegations would have been subject to a defamation suits. This case, and then the question has to be, well, so yeah, those are, you got to think that the judge is not going to consider those things. But in fact, the judge did consider those things and actually put it in her impressions, I believe, in her judgment. I further wish to point out to this court that this judge admitted, I believe it was in the impressions portion of her judgment, I'm sorry, the trial court's judgment, I apologize. In the impressions portion of the that there wasn't enough evidence for this court to make a decision, and that she was going to dismiss it. And she held it, the trial court held it for 2 years, waiting for someone to come up with hidden assets. What is it, hidden assets?
Counsel.
What was she waiting for?
Counsel.
I'm sorry, Your Honor.
Well, the thing is, I know you're venting to some degree.
No, I'm very passionate about this. This is.
Well, I understand, but I guess my point is, though, which of these assignments of error? I think you've already said it doesn't even deal with any of these assignments of error.
This court has the authority on its own
On what page?
to make a decision based on other grounds, other than were raised by the appellant. and because I believe that I have raised the issues, meritorious issues that show the prejudice that my client incurred. Specifically, the trial court making decisions, finding that there was violations of the orders, the pretrial orders, when in fact there weren't. Where it said marital, and in fact in the judgment, the trial court says this is not a marital asset, but still there's a violation of the order, when the order only said marital assets. With regards
And that
to,
is one of your assignments of error.
right, with regard, and in the brief, I believe I've set forth those arguments, those what I believe to be meritorious arguments and clear indications of abuse of discretion. But that still cannot convey what happened in this case. What happened here? And I can only raise those issues that I believe that materially affect my client and materially prejudiced my client and were clear abuses of discretion. And I think I've done that. And I can answer any question you might have with regards to any of those 7 assignments of error. However, that does not clearly convey everything that happened here. And so I guess I'm asking this board, please review my errors. There is error. I believe I've established that there is error there with regards to my client, with regards to the child support, not awarding any child support and not saying anything about what's in the best interest of the child with regards to that child support pursuant to statute. Miscalculating the child support based on this court's own authority and particularly not including the amount of money that was ordered for him to pay to her as part of her income. This court's repeatedly ruled on those, and those were clearly not done. I mean, all you have to do is look at the calculation sheet. It's not there. With regards to the support that was ordered, the spousal support that was ordered, it was based solely on 2 alleged extra jobs. One of which he insisted was a 3-month job under a contract, and he presented the contract. All I can say, because the other claims were all dismissed, so it kind of almost looks like it kind of whitewashes it, except for the fraudulent conveyance of the GTO, which was clearly not a fraudulent conveyance. He had a clear title, he had a legitimate title, and sold it to the guy. It was under the title law, not the fraudulent conveyance statute of Chapter 13. It comes under the title law, auto title law. But the only way to get some form of justice in this case is to actually look at what actually happened, reverse the case, and remand it for a new trial. Thank you. Any questions?
Doesn't look like there are. So thank you very much for your presentation.
I apologize for my passion.
I have to apologize.
The court will take the matter under advisement, issue a decision. You will be mailed a copy of the decision the day it's released, and the opinions are also posted on the Supreme Court of Ohio's website. The court is adjourned at this time until July 10th.